Good afternoon, everybody, and I would like to welcome you to this panel that is part of the Refugee Law Initiative annual conference. And the title of the panel is The Future of Complementary Pathways. My name is Vladislava Stoyanova, and I'm an associate professor at the Faculty of Law, Lund University, and I'm also a senior research associate with the Refugee Law Initiative. And this panel is designed to probe questions about complementary pathways. These legal pathways are promoted as opening new spaces for solutions for people in need of international protection in addition to resettlement. And the panel is designed to inquire into whether these complementary pathways actually can live up to certain expectations, because they have been presented to us as serving certain expectations, such as easing pressures on host countries, enhancing self-reliance on behalf of the people in need of international protection, expanding access to third country solutions. But there are many open questions surrounding complementary pathways. For example, one question that can be asked is purely descriptive question in terms of trying to understand all kinds of practices that can be labeled at national level as complementary pathways, and also legal questions as to people who arrive through these complementary pathways, actually what rights are attached to their status once in countries of destination in terms of, let's say, the type of residence permit granted, the duration of this residence permit, and their rights to family reunification, for example. So the panel today has 4 speakers, and each one of them will be granted 10 minutes. And according to the instructions that I have received from the organizers, I have to be quite strict when it comes to the enforcement of the limit. And I will introduce each speaker just before they start to speak. At the end of each presentation, we will have a discussant who is going to share her reflections on the main arguments forwarded by the presenters. And according to my calculations, at the end of the panel, we should have about 20-30 minutes for questions from the audience. During the session, please pose your questions and comments to the speakers by typing them in the chat box. And in terms of technicalities, I would like to also say to everybody to turn off their mics and their cameras unless you are presenting. This session will be also recorded, so if for some reason you don't want to be in this recording, you can leave the session now. Without further ado, I would like to give the floor to the first speaker, Dr. Joanne van Selm, who is an independent consultant on migration and refugee policies, and she's based in Washington, joining us from Washington. And she is the research director of EU Asylum, and she has conducted research on complementary pathways for the International Organization of Migration, UNHCR, International Catholic Migration Commission, and has written broadly on issues of resettlement also and complementary pathway. So Joanna, you have the floor.
Okay, are we good to go? Thank you. Okay, so the question that I have posed myself is, whose pathways are these anyway? I was very grateful to Vladislava for the invitation to participate in this panel, because it gives a chance to step back and to think. And so this is very much a kind of think piece that I'm going to be presenting to you. What I'm going to do in this presentation of just 10 minutes is give a few underlying thoughts on complementary pathways that inform the rest of the paper and the presentation, present the key question and ask a couple of sub-questions to it, address the central issue that thinking about this has allowed me to come up with, which is whether complementary pathways are a top-down or a bottom-up kind of a policy issue or approach, or if it's one or the other or both, and what's the balance between the two. And then to look at 4 different perspectives on complementary pathways, that of communities, of governments, of the international regime, and of the beneficiaries. And then to just highlight a few preliminary conclusions, because obviously this is in progress. So those underlying thoughts on complementary pathways, I have 8 key features or characteristics that I think it's useful to bear in mind. Others may contest them. The first is that this is a relatively new form of organized arrivals. It's been quick off the mark, and it's good to take a pause for reflection, I think. Complementary pathways are flexible and varied. They're constantly branching out and developing. So it's not as if there's one fixed, rigid approach. This is a complementary pathway, but they're in development all the time. Thirdly, complementary pathways are designed to provide safety and respond to facets of a beneficiary's identity that go beyond their protection need. So it's not just, do you need refugee status, but do you have other aspects to your identity or to your life that could be responded to through this approach. I think complementary pathways are generally, we could characterize them as inclusive of a range of beneficiaries, but also of a range of actors involved in destination countries. In terms of scale, they're relatively small for the number of arrivals to date compared to the need, but there's plenty of scope for growth. But most of the individual pathways are also relatively small in scale. So in total, but also each individual pathway that's been developed or created to date. Sixthly, I'd say they're not a fix-all. Sometimes complementary pathways are referred to as something that's going to solve all the problems of the refugee policy system, and they clearly are not going to. And in particular, number 7, I think there is the danger that governments present complementary pathways as alternatives to smuggling, something that can break the smuggling networks through organized and managed arrivals. And unless the scale grows exponentially, there is obviously no way that that could possibly happen. Lastly, it's the obvious point of what's the complementary. We always say it's complementary to resettlement, but I think it's important to bear in mind that they're also complementary to asylum, and they sit in a range of refugee policies, and they need, complementary pathways need to respect the rights that we already have well established, not just through resettlement, but also through asylum and other means of arrival. So moving on then to my key question, which is a very simple, straightforward question of whose pathways are these anyway? Who creates the pathways would be one sub-question to that. To date, I think many have been government, especially the larger ones, government inspired, but also civil society inspired. And we see increasingly with AMIF funding, EU-inspired approaches to complementary pathways, universities, employers, new NGOs, such as Talent Beyond Borders, and obviously the impetus from UNHCR. So who creates the pathways? Those are the range of actors. One actor that's obviously not there is the beneficiary, because it would be hard for them to create the pathway, but they're created for them, of course. Secondly, why are complementary pathways created? I think answers there include management, sense of control, and a broader range of opportunities for all people involved in the pathways. And how are they created? I think what we've seen to date, if we think of complementary pathways like the humanitarian admissions program in Germany, there was a lot of lobbying from families, from Syrian families, to have some means of bringing their family members to Germany. The response to that, I think we see that kind of lobbying in a lot of places. We've seen it here in the US for Ukrainians, where a form of community sponsorship has been opened up for Ukrainians. But I think if we start asking whose pathways are they, what we're asking about is ownership. And then the question is, like, why do we ask about ownership? And I think it's good to reflect on ownership. And going back to Vladislava's question of, are they living up to expectations? We need to get into the heart of complementary pathways a little bit and ask about whether they're achieving their goals. there's been a rush to create something, but with every growth, it's good to take a moment of consolidation. I think it's a good time to start asking those questions. Do complementary pathways in terms of ownership, for example, mostly satisfy government's wish to say that they're acting, they're being humanitarian and they're organizing movement and not leaving it all to the asylum system and to the networks that allow the movement to happen? Do the complementary pathways allow some destination populations to feel more involved, more engaged? Is that a good goal of them? Does that give ownership over the complementary pathways? And is another point to think about is how they broaden the protection offering to be more inclusive. Resettlement, for example, being very focused on vulnerabilities, can leave out those people whose main vulnerability is being a refugee and not another identifying characteristic that would include them in a resettlement program. And so complementary pathways allow the movement to them. So it could be all of the above, but the major policy point here, I think, is to be aware of who has ownership, why and how. And this question of top down, bottom up, why ask, are they top down or bottom up? I think a top down approach signifies consistency and suggests the maintenance from a higher level of a kind of just and fair approach. A top down approach also gives that implication of the sovereign control over borders and admission, and ensuring that rights and entitlements are upheld and that duties of all involved are respected. A bottom-up approach to a policy such as complementary pathways, meanwhile, adds a range of flexibility or buy-in as well to the policy. And having a bottom-up approach to creating complementary pathways can strongly express the kind of human or people element to the pathways. At heart, I think there's a question of what's the balance here in terms of the policy, law, practice, and approach. Not just in terms of ownership, but in how they're put into effect as well. And so then I turn to look at the four perspectives. Communities, as I've said, complementary pathways are allowing more engagement. Communities have been in destination countries have been very central to the development of complementary pathways, both in terms of lobbying or pressure, like the example from Germany that I just gave, and also through sponsorship initiatives. Through employment, it could just be, one or two people whose protection and safety is guaranteed that way, but people get involved, employers are getting involved, scholarships obviously from academic institutions as well. A lot of these draw, of course, on the Canadian private sponsorship program, which I personally would suggest, and again, it's often a subject of discussion, is not a complementary pathway because it's long been part of the resettlement program. But these things are fungible, and it certainly has given inspiration to many people. I think the main point on communities is that clearly there's enthusiasm that can be harnessed, and we see that in many countries, getting populations active and proactive in complementary pathways, and that can knock on into other elements of the refugee protection regime. But it's clear that safeguards are needed, and so those come from the top, obviously, and the bottom-up element is kind of pushing the envelope on numbers, on style of program, on who can be involved. Secondly, the perspective of governments. And I think we have to remember that there's many governments involved in a complementary pathway. Obviously, the destination country's government, but also the government of the country of first asylum, where solidarity is being expressed through the complementary pathways, and the movement of some people for protection elsewhere. And of course, also the country of origin is involved, because a complementary pathway, in not offering refugee status, leaves the actual protection of the individual in many ways in the hands of the country of origin. And that can give rise to questions about how complementary pathways fulfill the protection need. So the main points, I think, that I've come up with so far there are how governments need to have that role for control and for status and legal issues and for safeguarding, and that top-down action can ensure a smooth process. But sometimes it might also mean that there's too much caution, that it's not going where the population is ready to go in terms of the opportunities and the support that can be given. The perspective of the international protection regime, I mean, as I've said, I think we have to see complementary pathways as part of that whole of refugee policies. Obviously, there's encouragement to generate them in the Global Compact, in the language of the Global Compact. And in many ways, from the point of view of the international protection regime, complementary pathways can be viewed as an entry point to more resettlement. So they can have that knock-on effect of allowing more protection places, more solution places through resettlement. So there's a top-down element there of the international regime prodding governments to get into action, to develop these pathways. So the main points there being that link to the overall regime, the expression of solidarity, and being wary of pitfalls in terms of things like numbers and that contrast between the good refugees or the good organized movers and the bad asylum seekers and immigrants. We need to be very wary of that from the point of view of the international protection regime. Lastly, the perspective of the beneficiaries. In theory, they get to express their identity beyond the protection needs and use the skills and connections. However, in practice, many people who could benefit from complementary pathways don't know how to access them and need support in doing that. And that is seems to be one of the last elements that comes in. I've seen some NGOs trying hard in Jordan and Lebanon, for example, to set up programs to encourage access. So then the question of that bottom up becomes, are we really getting any input from the beneficiaries and from the communities? So very quickly in 4 words, preliminary conclusions, we need a balance between that top down, bottom up, I think, and to make this happen smoothly and well, allow pathways to happen. Safeguards are obviously key to that balance and to where we find the pivot point in it. We need to develop trust and understanding between that full range of actors and use complementary pathways to strengthen the whole of the refugee protection system. Thank you.
Thank you, Joanne. I think this framework that you propose, top down and bottom up, it's very useful and has a very powerful explanatory force simply to better understand them and to describe all these diverse practices. So thank you for the presentation. I would like to move to the second speaker, which is Professor Mariolene Ziek, who is a professor at University of Amsterdam in the Netherlands. I mean, she has rich scholarship, but particularly in this context, I have to certainly mention her work on resettlement that we are all familiar with. Professor Ziek, you have the floor.
Thank you very much. It's very nice to be in this panel. It was a very interesting presentation by Dr. van Zelm, and I think there will be probably some overlap. Complementary pathways have the appeal of adding new possibilities to traditional solutions to the problem of refugees. And I think for those who will be able to access one of them, a temporary respite to exile. Even so, the concept of complementary pathways, I think, is obfuscated. The pathways themselves are inherently problematic, and the alleged beneficial side effects UNHCR claims they have unconvincing. UNHCR's 3-year strategy on resettlement and complementary pathways, which was issued pursuant to the Global Compact, describes the complementary pathways as pathways that provide safe and regulated avenues for refugees that complement resettlement by providing lawful stay in a third country where their international protection needs are met. They're additional to resettlement. The complementary pathways include humanitarian admission, community sponsorship, humanitarian visas, family reunification, third country employment, and third country education. It's not clear why some of those pathways have not been categorized as variants of resettlement. Much, of course, depends on how resettlement is defined. UNHCR defines resettlement as the selection and transfer of refugees from a state in which they have sought protection to a third state, which has agreed to admit them as refugees with permanent resident status. Leaving aside the fact that this definition omits to add the reason for the transfer, which is unmet protection needs in the country of asylum, providing refugees with a permanent resident status is not set state practice. Quite some states grant resettled refugees a temporary permit similar to what they grant spontaneous arrivals. that does not preclude resettlement from turning into a durable solution following naturalization, just as the temporary permit granted to spontaneous arrivals may turn into the durable solution of local integration. UNHCR distinguishes humanitarian admission from resettlement on account of the use of eligibility criteria that are not based on a need for protection. However, the use of such other criteria is, alas, part and parcel of resettlement practice. Another feature that would set humanitarian admission apart from resettlement is the fact that the refugees are granted a temporary status. As indicated earlier, the assumption that this is different in resettlement practice cannot be sustained. Humanitarian visas are used to admit persons in need of international protection to a third country, and those are also distinguished from resettlement. Those visas are key to the humanitarian corridors, which have been devised by faith-based organizations in Italy and elsewhere. A private initiative, of course, enabled by and with the consent of the states involved that issue the requisite visas. The selection of candidates based on need for protection, reception, and integration are performed by the faith-based organizations. More about those specific corridors by Professor Ricci later on. In view of UNHCR's definition of resettlement, I would say it's very hard to argue that this all sets the corridors apart from resettlement. Comparable questions can be raised with respect to private sponsorship of refugees, arguably a form of private resettlement. It's not clear why UNHCR is not considering it a form of resettlement, perhaps because the selection of the refugees is done by private actors rather than by UNHCR, and it's not confined to refugees with protection problems. But it should be added that some programs, and I think in Australia we heard earlier this week, and also Canada, have programs which include private sponsorship of UNHCR referrals. Family reunification is another complementary pathway. However, the fact that it is a rights-based form of entry cost is being classified as a freestanding and distinct pathway in UNHCR's Roadmap 2030, the sequel to the third-year strategy. So leaving, therefore, family reunification aside, the only pathways that clearly can be distinguished from resettlement are those which are not based on protection needs and are of a temporary nature. Third country employment and third country education. In view of the substantive similarity, and of course there are broad brushstrokes, but in view of the substantive similarity of the other pathways with resettlement, the remainder of the presentation will focus on those two pathways that are complementary in the sense of being categorically different from resettlement. And I think they're also problematic. First of all, they're inherently discriminatory. As to labor, third countries will focus on their labor or skills shortfalls. That entails that labor in a third state will not be an option for refugees without skills. Education, which is short for higher education, means access of refugees to a third country, and I quote UNHCR, based on their education and language skills as opposed to their protection needs. End of quote. It's consequently not an option for those who do not have the requisite diplomas that give access to higher education. Obviously, I want to underline that the benefits for those refugees who may qualify for labor or education abroad may be great, but the discriminatory nature of those pathways cannot be reconciled with one of the guiding principles UNHCR formulated in its 3-year strategy, to wit that of non-discrimination. Again, a quote, refugees should be treated equally and have a fair prospect to access third country solutions, irrespective of their age, gender, and other characteristics, end of quote. Second, the focus on ways out of the country of refuge excludes a focus on the country of refuge. After all, if the country of asylum would observe the rights listed in the 51 Convention, 1967 Protocol, human rights treaties, a way out would not be required, only for those who nonetheless have genuine protection problems in that country. UNHCR suggests that the refugees concerned may acquire a permanent residence permit or may apply for asylum upon completion of their study. I quote, during or upon completion, students may have the right to apply for asylum or request an extension of their studies in accordance with national legislation and policies, end of quote. What does that mean? Can the country of temporary deny an asylum claim with reference to the fact that the refugee concerned enjoyed asylum elsewhere prior to him or her being admitted to the country of study. If asylum is denied, should the refugee return to the country of refuge? Is that country bound to readmit that refugee? Comparable questions have been raised earlier this week by Professor Van Kova regarding labor. It demonstrates that the transfer of the refugees concerned is not about protecting the refugees as acknowledged by UNHCR, which observed that some pathways may not feature sufficient safeguards to meet the unique protection needs of refugees. Complementary pathways should be in addition to resettlement. And the question is, what does additionality mean? Probably that the complementary pathways may not negatively affect the number of available resettlement places, nor be offered at the expense of resettlement places. According to the New York Declaration, resettlement and complementary pathways should jointly meet the annual resettlement needs as identified by UNHCR, currently recently estimated for the next year to amount to 2 million persons. However, even if 100,000 refugees could be resettled annually, and it's rare, it happened this century only twice, that would mean that 1.9 million places should originate complementary pathways. Apart from the fact that this figure can hardly be called additional to resettlement, those 1.9 million refugees have been identified based on their need for protection. And it is a moot point whether they qualify for the non-protection-based complementary pathways. UNHCR claims the complementary pathways will ease pressure on host countries. In the 3-year strategy, it's suggested that 2 million refugees would be resettled or found a place elsewhere by means of a complementary pathway in 2028. That means 300,000 refugees in 2023, 100,000 through resettlement and 200,000 via complementary pathways. One way or another, 300,000 is a lot of people, but it's a modest number when set against the entire refugee population, which is over 21 million refugees, so hardly capable of easing pressure in the sense indicated. If that is what should be pursued, and the Global Compact suggests it should be pursued, I think more effective would be to devise a distributive mechanism based on equitable criteria. A second claim consists of enhancing refugee self-reliance. Refugees can acquire and retain skills that can assist them in working towards a sustainable solution in the future. Undoubtedly, the pathways, again, focusing on labor and education, will contribute to self-reliance. But if that is the goal, the question is whether the complementary pathways are the most effective way to accomplish that. After all, realizing economic self-sufficiency is the ratio of the rights catalog included in the 51 Convention. It was at the time a clear break with the immediate past. It would therefore, I think, be more effective if UNHCR would exert pressure on host states to observe the treaty obligations, which would enable many more refugees to acquire skills. A related claim is that those skills will assist in working towards a sustainable solution in the future. But what is a sustainable solution? If the reference is to the traditional durable solutions, it's not clear how self-reliance may contribute to realizing those solutions. Voluntary repatriation, after all, is dependent not on the acquisition of skills, but on a change of circumstances. Local integration does not require skills, but naturalization, and resettlement is predicated on specific needs for protection. So it's not predicated dependent either on the acquisition of skills. The third claim is that the pathways lead to a net increase in third country solutions for refugees. The only thing that can be said is that the pathways will give some refugees the chance to study or work abroad, which is not tantamount to a solution to their plight. It may be, but in the absence of legal commitments, this claim seems to be an instance of wishful thinking rather than anything else. In view of those flaws, and I echo here my predecessor, the absence, and I would say the absence of beneficial side effects, why does UNHCR embrace pathways that are not based on a need for protection elsewhere? Perhaps the structural, I always thought that was the case, perhaps the structural shortage of resettlement places forced it to suggest alternatives to resettlement. But the alternatives do not benefit those who it annually identifies as in need of protection elsewhere. What is needed simply is more resettlement places. Thank you.
Thank you, Professor Ziek. Now, as opposed to Joanna, who I think her framework is useful for perhaps describing them and better understanding complementary pathway, as your presentation showed, they can be extremely controversial also, and you raised nicely the reasons why. Without further ado, let me go to the third panelist. This is Emilia Bratanova van Harten, who is going to talk about complementary pathway as effective access to means of legal entry in the reasoning of the European Court of Human Rights. Emilia is a doctoral candidate at the Faculty of Law, Lund University. Emilia, you have the floor.
Thank you, Vladislava. And good afternoon, everybody. It is a pleasure for me to be part of the 6th annual conference of the Refugee Law Initiative. You should be able to see my presentation now. And today, I'm really pleased to share part of my PhD dissertation project with you, which is focusing on legal pathways for people in need of international protection in Europe, from access to territory to refugee integration. And more specifically, today I'm going to speak about the place of complementary pathways in the case law of the European Court of Human Rights. But just before going into the detail, I would like to give you a very brief background of the project. As I said, this is part of my dissertation project and I'm still in the initial phase. This is part of a broader project called The Borders Within, the Multifaceted Legal Landscape of Migrant Integration in Europe, led by Associated Professor Stoyanova. And in the future, upcoming, I'm planning to focus on the case studies of Spain, France, and Ireland. What is the structure of the presentation? First of all, I'm going to situate complementary pathways in the current migration and asylum context, and then in European human rights law. Then I'll look at what it means for complementary pathways to be framed as genuine and effective access to means of legal entry in the case law of the European Court of Human Rights, and what is the function of this concept. And in the end, what it means for the future of complementary pathways. So to start with, we should remember that complementary pathways function in a specific asylum and migration context. I'm looking at the EU context. And what matters here is the relationship between the need to have legal channels to reach the European Union in a context which is characterized by containment and externalization that we spoke about yesterday and the day before. The European Commission sees the availability and the establishment of complementary pathways as a win-win situation with partner countries. These are third countries. Mostly countries of transit. So in the European Union, it can be said that complementary pathways are seen primarily as a migration management tool and as part of a cooperation partnership with third countries. However, we need to keep in mind that there is no legal obligation to establish complementary pathways. But once established, they interact and must comply with international law and with human rights law. And so today I'm focusing on the legal aspects of complementary pathways, and more specifically on how do complementary pathways function as a legal concept in European human rights law. It has already been mentioned what complementary pathways are, so I'm not going to dwell on that. So going directly to the European Convention on Human Rights, we should say once again that there is no right to asylum contained in the European Convention on Human Rights, and there is no right to a third country solution. Basically, there is no right that would interfere with the right of states to control the entry of non-nationals into their territory. However, the court has also stressed that the problems which states may encounter in managing migratory flows or in the reception of asylum seekers cannot justify recourse to practices which are not compatible with the convention or the protocols thereto. De Boer and Ziek have already made an analysis of the human rights of refugees who undertake resettlement in Europe. And unfortunately, the conclusion in their article of 2020 is that even if the jurisdiction hurdle could be overcome, the resettlement selection procedure currently does not trigger any of the rights laid down in the European Convention on Human Rights. We could come to the conclusion or the assumption that probably this would be the situation of people who arrive under complementary pathways. But of course, we can also think of some scenarios where some human rights could be triggered in cases of for example, expulsion in case of loss of the permission to remain in the country for such people who have arrived under complementary pathways, or in the process of application if they get a rejection under certain conditions, and then probably articles 3, 8, 13, 14 could be triggered. But looking at the current state of affairs, the situation is such that complementary pathways exists in the case law of the court as part of a test in protection of the right to protection from collective expulsion of aliens, that is Article 4, Protocol 4 of the Convention. And in relation to that case law, there are links to Articles 3 and Articles 13. So we're looking at cases that pertain to hindered access to territory which with alleged breach of the protection from collective expulsion. And I claim that complementary pathways are contained within this phrasing of the court, which appears in the case of NDNNT versus Spain in 2020, namely genuine and effective access to means of legal entry, in particular border procedures. But it is not only complementary pathways that are examples of such means of legal entry, and this is why you see under point 3 that we see border crossing points of a sufficient number, which has not been defined. But there are also examples of working visas and visas on humanitarian grounds. So what is the place of these means of legal entry in the reasoning of the court? In the assessment of whether there has been collective expulsion, first of all, the court analyzes where the practice can be characterized as expulsion, and if that is the case, then the second question is whether it is collective. So what does it mean for a practice to be characterized as a collective expulsion? That would be the absence of a reasonable and objective examination of the particular case of each individual alien of the group. However, the court also specifies that Article 4 of Protocol 4 does not guarantee the right to an individual interview in all circumstances, and importantly introduces the test of culpable conduct, which means that there would be no violation of Article 4 of Protocol 4 if the lack of an individual expulsion decision can be attributed to the applicant's own conduct. This is not a new concept introduced specifically in this case of NDNNT versus Spain. However, for the first time, the court is giving substance to the culpable conduct and makes it part of a formal test. And so what does culpable conduct include? On the one hand, that would be cases where persons cross using force in an unauthorized manner, on the one hand, and on the other hand, where the respondent state has provided genuine and effective access to means of legal entry, in particular border procedures, and the applicant has not made use of it. So going to the discussion, which is, I believe, the most important part of today's talk, is what does this mean for the future of complementary pathways? One could probably think that if complementary pathways form part of the culpable conduct test, that could be an incentive for states to introduce such complementary pathways. But I would disagree with that. Because in the end, the focus of the court is on official border checkpoints. And in some of the following case law after NDNNT versus Spain, it has not gone to analyze the presence of other complementary pathways if it has been convinced that there is effective access to official border checkpoints where people can apply for asylum. Moreover, in the NDNNT versus Spain case, the court introduces a jurisdictional threshold, which means that basically the court does not consider the assessment of the reasons for non-effective and non-genuine access to the established legal entries before the applicants physically reach them outside of the jurisdiction of the court, which means basically that it doesn't assess the reasons why it is difficult for people in need of international protection to make use of these legal complementary pathways in the first place. And then, of course, there is a shift of responsibility on the individual if such complementary pathways exist. One could probably say that if there is a proliferation of complementary pathways, it will become much easier for the court to deprive applicants of protection from important human rights. Could we claim that if complementary pathways scale up, they will be able to live up to the expectations to provide protection and reduce irregular arrivals? I would be cautious to draw such a conclusion, and I would call for a need for an ongoing assessment of the protection safeguards that complementary pathways go together with. And with that, I thank you for the attention.
Thank you, Emilia. Thank you for placing complementary pathways within the, or trying to place them somehow within the human rights law framework in light of the existing case law of the European Court of Human Rights. And also, in a way, in light of the last slide that you have, in continuation of Professor Z's critical approach, asking the question whether by having these pathways, it might be easier actually to undermine human rights law more generally. Let me now move to the final presentation for today by Professor Carola Ricci, who is based at the University of Pavia in Italy. And her presentation will be about humanitarian corridors. Carola, you have the floor and you can share your PowerPoint.
Thank you. Thank you, and the organizers for inviting me to share my ideas, but also to share ideas in general in this such unique three half days of stimulating experience. So my small contribution will be to present you all the community-driven humanitarian corridors experience in Italy as one of the different feasible complementary legal pathways to mediate the obligation to protect the vulnerables and state deterrence. The main feature of these humanitarian corridors, just already mentioned by Professor Zieg, the so-called humanitarian corridors has been open thanks to private sponsors and mainly different faith-based organizations in favor of mostly right now Syrian citizens from Lebanon and other vulnerable people from Ethiopian camps and Afghanistan from 2021. The community-driven nature of these corridors is characterized by civil society engagement in supporting refugees to facilitate the identification of best possible, quote, pathways to a long-lasting integration. So it's an uncommon model of public mobilization of the civil society, including refugees in synergy with the state, as it has been defined by some authors. So there differs from research models, as it's already been underlined, just because of the role of the civil society engagement, of the role also of the autonomy of the individual is directly engaging the potential host state in a procedure aiming at securing physical transfer and legal protection. So again, focusing on some of the main features, for sure, civil society engagement is visible in pre and post departure phase by matching of the specific sponsor communities and beneficiaries before departure. And there's a very peculiar mutual agreement by both sides. They are both prepared by the involved NGOs on what to expect, both as a hosting community, but also as a beneficiary, in order not only of a cultural backgrounds that it will meet, but also legal and legal principles. Like, say, for example, Italian constitution is explained before leaving. Italian language is it's already tackled before the departure. And obviously identification is another fallout that actually is allowing state security in a, they say, most effective way. Under the humanitarian corridors model, the NGOs are bearing completely the costs of the transfer and integration, but also the following procedure to obtain international protection that they had to ask as soon as they land in Italy. So the aims of these corridors is at exactly stabilizing the beneficiary. So this is clear and must be clear since the beginning, even before the departure. Vulnerable people are defined broadly within the Memorandum of Understanding, and they are including not only those considered by UNHCR as deserving as at least prima facie the recognition of status of refugees, but also people from whom there are reasonable grounds to believe that in case of return to their countries of origin, they would suffer significant damage, also as a consequence of situation of armed conflict, endemic violence, or systemic violation of human rights. And moreover, also person in need of their personal vulnerable objective condition of health and or age. So people in need of medical care, person with disabilities, elderly, minors. There's a long list, even if it's not a definitive one. There's a plus factor, the existence of a sponsor community or family member already present in Italy, willing to support their integration and inclusion. The legal base can be found in the constituting hybrid agreements. These are public-private memorandum of understanding between the Italian competent ministers, foreign affairs and interiors, and the sponsored NGOs. Community of Sant'Egidio, Valdesian Board, Federation of Protestant Churches, Italian Bishop Conference, but also in the last months of 2021, in regard to Afghani nationals, UNHCR and IOM. All the memorandum of understandings are requiring Italy to grant an LTV visa under Article 25, Paragraph 1, letter A of the Visa Code. That actually can be right now still can be rendered by other member states whenever they consider necessary on humanitarian grounds for reason of national interest or because of international obligation, as you all know. But there is, as of today, no obligation to to grant such a visa, as already underlined, both under EU law and the European Convention of Human Rights, as specified firstly, I would say, by European Court of Justice in 2017 in XX versus Belgium, and by more recently, the European Court of Human Rights in MN versus, again, Belgium. Well, the point is that internally, so in Italy, some judges have started challenge to this jurisprudence, raising numbers of litigation on the issue of a temporary visa on humanitarian grounds before them as an urgent measure. I tried to explain myself a little bit better, making reference to very shortly some passages. In a first set of decision, the competent national courts, of first instance, that is the Tribunal of Rome, felt required as a judge called to protect the fundamental right to grant the appropriate urgent and protective measure to save the applicant from a specific actual, imminent, and documented risk to life, even if it recalls that no obligation to grant a humanitarian visa is binding upon Italian representative of political authority, so the ministers, that instead have a mere faculty. So the court here is recognizing the existence, because it knows that the existence of the case law by the Luxembourg and Strasbourg court, nonetheless is making a distinction. One is a political side and the other is the judiciary, still an organ of the state. The court added that it's not necessary for the purpose of the decision of the provisional measures to establish already what kind of protection could or should be granted later on at the moment of the expiration of LTV visa. So the will to remain under this decision is irrelevant to activate immediate protection. We can say that actually through this decision, a safe entry channel could be open for those refugees that could not be protected differently, even that could not be protected under the humanitarian corridors, because of the direct applicability of Article 25 of the Visa Code. So as a result of this interpretation, the Ministry of Foreign Affairs and the embassies, competent embassies, were obliged by the Tribunal of Rome to grant an LTV visa as an urgent protective measure. So applying a provision of Civil Code, of Code of Civil Procedure, Italian Code of Civil Procedure, Article 700. And I was just giving here some elements and details for those who are interested. There are more than one case. These are the, I would say, most important, most, explicit. But I have to add that in the execution phase, mostly of the second order, the Minister of Foreign Affairs maintained an obstructive attitude again, requiring arbitrarily that the complainants had to demonstrate a specific and social inclusion and integration path, which should be stable, structural, long-lasting, and financially properly covered, as provided by the Memorandum of Understanding. But so in a way, the minister was saying, well, we're gonna give you the LTV, but you have to ask to be inserted into the program of the humanitarian corridor. As a response, the tribunal, with a decree that is very recent, so 14th of December 2002, 14th of January 2002, imposed the ministers to issue LTV visa in 10 days without adding any other condition, because that request was a judicial request and autonomous and unconditioned. So the point is that this recent attitude that could open this new way of protection was reversed by very even more recent decrees. One is the first one I mentioned, that actually are just plainly referring to the jurisprudence of the European Court of Human Rights and European Court of Justice. But actually they are making no reference to other international law sources. So they are just referring to that regional integration instruments, but not, strangely enough, to global obligatory instruments and obligations stemming out from customary law, common principle of international law, and conventions. The only one convention that is, in a way, granted, I don't know why, but more value and is recognized as being binding anyway and imposing the grant of a visa is the New York Convention of the Right of the Child, just in the first case. So it was recognized the right of a minor to be granted a visa to join the mother in Italy that actually was herself displaced there as a refugee, but had no possibility under the visa she was enjoying to reunite with them. So the first reverse attitude was confirmed by subsequently very recent decree that I found. And as a result, one could maybe argue that Article 25 of the Visa Code and its reference to included into the memorandum of understanding should be considered as tricky, or maybe, in my opinion, redundant. Why should we refer to Article 25? We know the history of this article. And instead, why shouldn't we make reference to international obligations stemming out from other global, potentially global sources of such obligations, erga omnes applicable? And that's the example of, that's a choice that was made by France, while actually signing other MOUs, other memorandum of understanding that are not making reference to Article 25, instead to international obligation and humanitarian reasons. So to conclude, despite the promising outcomes, some concerns remains to be tackled. So I am a positive thinker, but still I know that concretely applicable selection criteria and transparency procedures should be followed to avoid too much discretion. Mostly if we want to enlarge such a model to other EU states, finding of a balance between community volunteering and professionalism, because right now the NGOs involved are professionals, but what if we enlarge such a possibility following the recalled Canadian model? Avoidance of possible discrimination at the moment of the selection of the beneficiaries, that's possible for human. Still, maybe the clarification of the criteria could be helpful. Should not be used as a threat to the availability of other channels. For example, flexible creative judiciary solution as the one that we saw, that obviously is left to the discretion of another organ of the state, the judiciary, that is opposing to the political government decision, but still is a state act, or in case omission. So still remains an actual urge. We know that, and it has been remembered several times, these complementary paths are not a fix-all solution, but at the same time, they can anyway show a new game change perspective to modify the narrative of good refugees, bad asylum seeker, queue jumper, as being recalled by Professor Fogel yesterday. So a top-down approach would help, but maintaining a multi-stakeholder approach, as has been already remembered this afternoon at the beginning by the keynote speaker, actually is a necessity as well. Solutions might be in compliance with international law with regards to the extraterritorial nature of, among many, right to life, to health, not to be tortured, to have access to justice, principle of non-refoulement, best interest of the child, and family union. Thank you for your patience and attention.
Thank you, Carola. Now we are a little bit behind the time, and now it's my with great pleasure I would like to give the floor to our discussant, Anna Gecht, who is a Senior Complementary Pathway Officer at UNHCR Division of International Protection at the UNHCR headquarters in Geneva. And having already said her title and her function, I think it's quite obvious why we have invited her during this panel. Anna has been working for UNHCR for many years. And before that, she has been engaged in different works at different NGOs. Anna, you have the floor, and as a discussant, I think you have quite a lot of discretion exactly how you might want to structure your comments or which aspect you might choose most valuable to address. You have about 15 minutes.
Terrific. Thank you, Vladislava. And thank you, everybody, for taking the time to think of complementary pathways and put your thoughts on paper. I think in this field of work, we all are, it's a trial and error process of figuring out what complementary pathways are, how they serve, where they come from, And every attempt to conceptualize and answer some of these questions is incredibly useful in answering some of those components that I had raised. So all the discussion points here have very much resonated with the work we have been doing here. And perhaps I could first do a little bit of a general, I guess, commenting on the field of pathways and UNHCR's role in it, and then we'll try to address some of the particular points raised within each of the 4 presentations. And in doing so, first thing I wanted to say is perhaps position what complementary pathways are and how does UNHCR relate to it. I think it had been mentioned already and definitions have been quoted, and I won't repeat it, that pathways, complementary pathways are legal entry points and opportunities for refugees to access certain countries for a variety of reasons. Sometimes they may be linked to protection considerations, and sometimes it could be family considerations. Other instances involve more of a skill set or educational background. I think it's important to highlight, and this perhaps touches upon all of the presentations here, a couple of distinctions that situate pathways as additional, it's been said, to resettlement, but to asylum space as such. And it's been mentioned a number of times here that some of the protection-driven pathways indeed are at times defined as resettlement by the states or fall very closely within the realm of resettlement because they are based on protection needs and considerations. While UNHCR has still some role to play, some work to do rather, in defining some of the policy components where it's been a bit of a learning curve before we felt ready to put some of these pieces on paper. I think the logic of protection versus non-protection needs very much resonates with how we are starting to think of the distinction between pathways and non-pathways. And another component that I believe has also been raised is who identifies and based on what. So protection needs identified based on resettlement criteria that are enshrined in the resettlement handbook and methodology and agreed with states. That has been the crux of UNHCR's approach when defining resettlement. It's also driven by specific quotas that are given for that kind of resettlement, while everything that's additional and outside of that quota has formed the space of complementary pathways. That said, that piece and the definition of complementary pathways, and again, it's been said already, it's very fluent, it's very flexible, and it keeps defining itself through different undertakings that are happening. One more point I would like to make kind of in a general sense is that for skills and education-based ones in particular, we have been leaning towards and arguing that this is actually nothing new, and the same applies to family reunification. However, discriminatory approach, which is quite obvious in some of the programs that are specific to foreign students' access and labor mobility as such, precisely discriminate as it exists right now. The legal framework discriminates against refugees trying to enter it. So our UNHCR's thinking when approaching the notion of labor mobility and education is more rooted on the fact of seeing refugees who get job offers, for example, or scholarship opportunities and admission to universities, trying to get through and getting stuck in the legal constraints and requirements that exist in the visa frameworks that are currently in place. What we would like to see out there is that anybody who qualifies and can get in to a university or find a job in the third country, being a refugee does not discriminate their capacity to proceed with that opportunity, which is currently is not the case. Because it's currently not the case, for now, the approach of many actors out there has been, and there are some exceptions to this, has been very much boutique tiny programs that are very much specific to refugees. Are those necessary, needed? Do they serve a purpose? Of course they do, because there is a very specific vulnerability implied within a situation of somebody who is a refugee. But in all recognition of the effort and the opportunities that are being given, the number of those people who would like to try their chances at getting through and obtaining these possibilities and being qualified to do so is much larger than the actual programs that have been boutiquely designed for refugees out there. So the end goal for us here is to open up access to large-scale student and labor mobility opportunities, particularly keeping in mind the fact that while they do fall short of asylum, they do not offer the protection safeguards as asylum would, such as non-refoulement by itself. The majority of those programs as they exist right now allow for continuous access to legal stay and eventual permanent residency and naturalization in most instances. Another piece here, and this touches upon the notion of self-reliance, which has also been mentioned, is that refugees we have been working with at UNHCR who are trying to get these opportunities and trying to come through actually prefer to, in many instances, to be recognized for what they bring to the table, as opposed to the protection needs that they may have. If many were posed with a question, is this enough? Is this something that you would pursue? Of course, there's not exactly that many options to choose from, but with the conversations with those who have benefited from pathways out there, and when I say pathways, it's really all the opportunities to go on education or labor mobility, and I'm speaking about these two right now more specifically, and I will touch upon the others. It's the appreciation of the fact that my skills, my education, my capacity to study, to obtain this opportunity is being recognized, and I'm given an opportunity to work, to study, to build my life, rather than being perceived in many ways as a protection, as a refugee in need of protection. So I think that's an important component that psychologically has to be also recognized, and to the point that refugees themselves have to raise their voices and be participatory in the design of these programs, the top-down, bottom-up argument. There's certainly a need and an attempt to make sure that their views are embedded within the program design when we're speaking of specific projects and programs that are very much refugee-centered. One more thing I would like to make sure, I guess in a general sense, when we speak of New York Declaration, Global Compact on Refugees, the 3-year strategy, and now the roadmap that's about to hit the ground, those documents, while UNHCR has been the secretariat for their issuance, they're very much global documents. It's something that was a commitment from international community, and it cannot be really, UNHCR is not the author of them. It's really something that was done in a very much global and consultative manner on all of those. And I want to reiterate the point. As such, so when we speak of that strategy, I wouldn't necessarily dare to attribute it to UNHCR exclusively. One more point I suppose I would make as relates to the notion of transfer of refugees going through pathways. Coming back to the notion of self-reliance, it's self-application, self-identification, and self-solution, so to speak, with supports that have been built and are being built within the infrastructure, and NGOs, civil society, governments come very handy to it. And yes, there's much more work to be done in that space to ensure that refugees do know how to access opportunities and do know what to do when opportunity presents itself. Also, well, for the time being, the visa frameworks are such that specific and very manual support is indeed needed for them to get through. In terms of numbers, well, I'm sure you have all seen the report, and it's for the time being the only stats report reflecting on the state of the art, so to speak, of complementary pathways. That's the UNHCR OECD study that has been reissued now every year. Last year's report was Global Indicators report for the GCR. And the numbers there are inclusive of, they are pitfalls to the numbers. It's not perfect stats by far. But at the same time, we are seeing many individuals from major countries of where refugees come from, benefiting from labor permits, family reunification permits, and education permits. And this is inclusive of the numbers of those who are doing this on their own, essentially. The majority of them have not really benefited from any programs that have been specifically designed for refugees.
Anna, I think that perhaps if you can wrap it up in one minute, if you have.
Sounds great. 2 points on the last two presentations, because I guess I focused on the first two much more so. I think the point of multi-stakeholder approach and ensuring that everybody has a piece of this conversation and is involved in pathways is indeed a crucial component of what pathways are. And I think the role of humanitarian visas as an instrument and a tool, not only for the humanitarian admission ones, but for others, such as education, for example, has not necessarily been explored well enough. And there's certainly room to see how it could be the instrument to go through. Coming back to my point of the discriminatory setup that currently exists for student and labor mobility in particular, and what Emilia has been talking to, I think it's interesting to see whether that is indeed an effective means of legal entry as the framework, and whether there's some rule and some way to assess how those requirements are prejudicial almost of refugee situation because of the need for documents for various elements that are very much not possible for somebody in a refugee situation to obtain. I have not touched about family reunification for now. That is actually not to say that we have completely taken it out of the realm of pathways. It is legal based. It is very much based on non-discretionary right to family unity. But if we go back to the definition as we have, well, it has existed, of complementary pathways as legal means of entry additional to resettlement, it still sits within that realm. And there's also two kinds of family reunification based on legal provisions, but also the discretionary programs that emerge as blend of community sponsorship or what have you out there, which also forms that realm. I will stop at this, because there's of course quite a lot to say, and back to you. Thank you.
Thank you, Anna. Now, there is one question in the chat that I think is very important, and for this reason, I'm anxious to raise it, and it's about the issue of durability, which is also related to the issue of integration. And this question is, let's see, by Anna Musneaga, who says that, could we say that conceptualization of such pathways signals UNHCR move away from the discourse of traditional durable solutions to a more broader conceptualizations of solutions that may not necessarily be durable? So basically, is this a signal that solutions should not necessarily be durable? And there is one more question here. According to the UNHCR, complementary pathways should be part of a progressive approach to comprehensive solutions. In other words, complementary protection should ideally lead to permanent resettlement. I don't like the fact that complementary protection expects refugees to find their own solutions while states can cherry pick the best applicants, which also links to Professor Zeek's critique in relation to discrimination. Now, I raised the questions and I would like to give 2 minutes, maximum 3 minutes, no, actually 2 minutes to each one of the presenters to react to Anna's reaction and potentially to address the questions that I just read from the chat. So I suggest that we take the same order, starting with Joanna.
Okay, thank you. Thank you for the other presentations and the great questions. On the question of moving away from traditional solutions to allow for temporary solutions, but not solutions, I think the answer to that, as I would see it, is yes and no. I think there's a question of getting creative. If states are not offering resettlement, then let's get creative, would be the thinking, I should imagine, and find other means by which something that looks like resettlement could happen. And from a policy or human perspective, if not from a legal perspective, and I'll leave that to Marjolein, from a policy perspective, I mean, and the human perspective, I think a lot of the people who wish to go on complementary pathways, particularly the employment and education pathways, may well be people who are not necessarily looking for a permanent solution, and it may suit their lifestyle. I've known many people who were in a situation where they could have applied for refugee status and chose not to. They chose to be a student instead because they saw that as more applicable to their life, or they chose to find a job instead because that worked better for them. So I think when we're talking about this, we have to be very careful ourselves not to put people into boxes and say, well, the refugee protection need is the most important factor in that person's life, because that individual may not actually see it that way and may see other aspects of their identity and their future as more important to them. And I think that speaks also to the discrimination point. I think we have to be careful there. Yes, we can see discrimination in each category, including in resettlement. You have to have these additional vulnerabilities. That is also in itself discriminatory. It's not open to all refugees, in part because the number of places are so low. But what do we compensate for those forms of discrimination by having multiple different pathways to which people can apply so that the overall picture is less discriminatory, even if each individual element of it appears to have discrimination in there? I want to do David quick justice. He asked about Ukraine. I would say, David, that for the Ukrainians, for the European Union at least, the Temporary Protection Directive is completely different from the complementary pathways. But I think from a policy perspective, what this demonstrates is that it's very problematic. We're trying to pass people out into different streams and approaches. What we're really looking for is protection for people who are in need of protection. And that should be much more straightforward, perhaps, than life is making it be. So that's kind of a start to an answer to that, but I've taken my 2 or 3 minutes. So.
Thank you, Joanne. Professor Zeek, you have 2 minutes.
There's so much. I'll try to be short. I think, you know, I very much agree, of course, with Joanna, but I think we also should go back. Why on earth do we have resettlement? I mean, the point of resettlement being inherently discriminatory. Yes, it is. But it is based on need for protection. As we talk about protection problems in a country of asylum, if countries would live up to their obligations under the various treaties, refugee or otherwise, we would not really need resettlement, because resettlement really is the answer to a failing or the incapacity or unwillingness of the country of asylum to live up to its obligations. I should add to that of course we should also take into consideration that we do not have a distributive mechanism, so we do not have a fair distribution of responsibilities. But that is another issue. I think if there will be a more fair system of sharing responsibility, things would also be different. But when we really focus on the refugee or resettlement submission criteria of UNHCR as laid down in its handbook, we're really focusing on those who have a very difficult life. Think of victims of torture. Think of those who are persecuted in the country of asylum because they're gay, like in Uganda. These are the kind of cases that, people who get a resettlement place, not something else. Complementary pathways, they are inherently discriminatory, but they're not predicated on the need for protection. They're really, the criteria are very different. And let me add one thing. I think it's an irony that UNHCR, who has been struggling with those extra or non-protection based criteria which are applied by states in the context of resettlement, is now embracing forms of transfers which, basically do link up or tie in or are related to all those criteria earlier, and still, I think, rejects in the context of resettlement. I think I leave it at that because there's so much more, but I mean, yeah, lots. Thanks.
Thank you. Emilia, you have your 2 minutes.
Thank you very much, Ladislava, and everybody for the interesting input on the topic of complementary pathways. I would also like to address David's question to start with, but it's also related to the other questions. So as I understand it, the concept of complementary pathways is an umbrella concept, and in that sense, it's quite broad for a reason. So in my view, such pathways for Ukrainian citizens would qualify as complementary pathways, exactly because it is outside of the framework of the Temporary Protection Directive, as you point out. But of course, the categorization of what practice falls within complementary pathways is raising a lot of questions. I can understand the reasons why the concept is broad. Basically, it aims to scale up and expand third country solutions. So if more practices fall within this concept, then that's for the better of people in need of international protection. But some of the questions that this raises is, of course, how to categorize complementary pathways, really. Who counts as a person in need of international protection? How is this established? Because in the end, as has been mentioned many times, the people who arrive under complementary pathways would not, in the general scenario, apply for asylum. They may, but they prefer not to. So what about the obfuscation between the difference between migrants and refugees? I think this is a question that we have not been able to address so far, but it deserves special attention. And that also holds true for the permanency of the solution. If we look historically at the development of the solutions framework within UNHCR, we can see that there has been a move starting from permanent solutions and then durable solutions and then comprehensive solutions. So the whole concept is expanding in itself, and then it's interesting to see and analyze how the temporariness of solutions adds to its development. Thank you.
Thank you. Carola, you have 2 minutes and the final words in a way.
No, please, not the final. Just a reaction to the, yes, the first maybe Anna question, because actually I hope I was clear in indicating such a complementary pathways peculiarity that is looking for a durable solution, because once they reach Italy, they have to ask for either asylum or international protection. So the idea is to urge, so to find a way to bring them away from a situation that is not humanly bearing, so putting them at risk, so that once they are safe, they can ask for international protection, activating all, even the traditional channels. But they also, thanks to the, let's say, limitative, let's say, interpretation of the Geneva Convention, once they are on the territory, as you know, jurisdiction of the state is applicable also under the EU Convention. And that means that, anyway, since they are already in Italy, they are more protected, always. So that's why I was trying to bring about the attention on such a creative jurisprudence that has been raising in these last months, because they are exactly trying to justify an immediate reaction by a state to bring in security, in safe place, people that are in need, and then to let them explain their situation, but at the same time to find an agreement before leaving on an acceptable solution that for sure, as regard labor or education, is temporary. But they know before leaving that, for example, even if they have a degree in engineering, they will be used for the library in a specific city while looking for other works, while getting the language better, while having the kids inserted in the schools and so on and so forth, all at expenses of the civil society. So to go back to Anna's questions, to me, I mean, the UNHCR is just an open-minded attitude, since resettlement numbers that we would love would be more. So I'm with Professor Zik as well, while waiting other creative solution, and these are with Emilia and Johan, should and must be found with an urgent, very urgent tension by all the states, because this is their obligation, and also civil society, because they are obliged as well in a different way, but this can be found in general comments of the covenants, both on civil and political rights and economic, social and cultural rights. Didn't want to spend so much time on this theoretical stuff, but it's not theoretical. This is actually entering into our own lives also as a subject of international society and community. Thank you.
Okay, thank you all for your interventions. I'm sure that there are many other aspects that we can discuss, but I hope that this conversation will continue in some other shape and some other format. I'm going to close the session. I hope David is okay with this. And I hope to see you again somehow soon.